Mr. and Madam Arbitrators, my name is Kaylin Johnson, and I represent Northwest Optics, Inc., also known as NOI, in this matter. We are here today because Carmen Hart Company breached their long-term supply contract with NOI. Under the terms of the contract, Carmen must buy a minimum number of eyeglass frames each month. NOI, in return, contracted to deliver those frames. NOI has delivered the eyeglass frames each month without any issues from Carmen. Carmen breached the contract 6 months ago when it ordered less than the minimum amount of frames agreed upon in the contract. Pursuant to the contract, NOI initiated arbitration. The contract called for 3 arbitrators. Each side could pick an arbitrator and would mutually agree on a third arbitrator. Each side had an opportunity to object to the other side's choice before going to arbitration. NOI chose Professor William Prasad. The parties approved of each side's choices and mutually agreed to the third arbitrator. In the course of preparing for hearings, Carmen went beyond typical procedure and searched metadata on Mr. Prasad. They discovered information that he did not include in his declaration of impartiality and independence and availability because he was not required to. Carmen now raises concerns about William Prasad's neutrality as an arbitrator. The arbitrators selected for this case are all neutral. Under the Revised Uniform Arbitration Act, Section 12 states that a selected arbitrator shall disclose to all parties any known facts that a reasonable arbitrator would consider likely to affect impartiality. These include personal and financial interests in the outcome of the arbitration and any existing or past relationships with any of the parties. Carmen argues that NOI selected arbitrator William Prasad will be impartial during the arbitration. They argue that William Prasad is connected to Lit Funds, a third-party litigation funding company that provides short-term financing to help defray the high costs of dispute resolution. Also, they argue that he has written an article about the vagueness of ethical sourcing in contracts and has worked with members of NOI's staff in the past, specifically attorney Constance Ford. William Prasad only has worked on 2 cases funded by Lit Funds in the past 2 years. Prasad has worked as a professor and arbitrator numerous times in his career. These cases were only a tiny fraction of the cases that Prasad has arbitrated during his career. Prasad admitted that he was unaware of the reasons for his appointment, nor about the involvement in any third-party litigation funder generally or Lit Funds specifically. There is no possibility for Prasad to disclose this information in his declaration because he was unaware of the connection to Lit Funds. In addition, Prasad's research on ethical sourcing makes him an expert in the field rather than a biased arbitrator. The idea of arbitration is to allow parties to select arbitrators who are knowledgeable on the issues of the case. Prasad's heavy research will only help the parties to interpret the contract and the central issue of ethical sourcing. Prasad disclosed this in his original declaration. At the time of the original declaration was submitted, Carmen had an opportunity to object to the articles regarding Prasad's neutrality, but they chose not to. Finally, Prasad made no mention of his prior relationship with Constance Ford because he did not remember her. Section 12 requires arbitrators to disclose personal relationships. Prasad has been a Barbary representative for several years. Barbary representatives work with a large amount of students to help prepare them for the bar exam. This means that Prasad saw thousands of students in addition to Miss Ford. He did not disclose the personal relationship in the declaration because there was no personal relationship. He did not even remember that she was a student of his at one point. Therefore, there was no personal relationship that Prasad was obligated to disclose. Despite these allegations, Prasad amended his declaration. Under Section 12B of the RUAA, an arbitrator has a continuing obligation to disclose to all parties any facts the arbitrator learns after accepting appointment, which a reasonable person would consider likely to affect impartiality. He disclosed that he had consulted the 2 cases funded by Lit Funds. There was no need to disclose his prior research on ethical sourcing or the relationship with Constance Ford because they did not reasonably affect impartiality. These 2 points did not require disclosure based on Section 12. Prasad went out of his way to ensure that the parties of his neutrality by specifically stating that the contacts won't affect his independence and he is only disclosing the contacts for the utmost caution and the interest of full transparency. Prasad not only disclosed what was required of him in the declaration, but he made sure to include other details for full transparency. It follows that this case proceed to arbitration because Carmen breached the contract when it failed to order the minimum amount of frames required in the contract. The contract specifically required Carmen to purchase a minimum amount of eyeglass frames each month. In October 2018, Carmen ordered less than the minimal amount. Carmen claimed it ordered less because NOI did not use ethical sourcing. Ethical sourcing, the process of obtaining products in a responsible and sustainable way, was not defined in the contract. The term ethical sourcing on its own is too ambiguous to be a binding obligation. This case should proceed to arbitration as stated in the contract. In this case, the selection of William Prasad as an arbitrator was valid under the RUAA. It was inappropriate for Carmen to look through the metadata in the first place, but even so, William Prasad is a neutral arbitrator with great knowledge in this field. It follows that the arbitration move forward with the issues central to this dispute, a breach of contract. Therefore, we respectfully request that we arbitrate these issues with the 3 selected arbitrators. Thank you.